We're going to talk next about actually questioning the witness and deciding on what your overall plan is for interrogating the witness, and then about some different questioning techniques that may be appropriate to one situation or another, and just as illustrations of the fact that there's more than one way to skin a cat. The very first question in your plan perhaps will be, what subjects do I want to cover and in what order? And the order can matter. If you take a very simple example of a serious personal injury case, you're the defense lawyer, you're naturally going to want to ask questions about liability and questions about damages, and actually that's the logical way to do things. What happened leading up to the accident, and then let's talk about the injuries that the plaintiff has sustained. But you might consider not being so logical, and you might consider starting, for example, with the damages. And if it's a serious case, questions on that subject may go for an hour, they may go 2 hours. And some lawyers have made the observation that the plaintiff is usually more interested in his injuries than he is in how the accident happened. And if you then spend a couple of hours talking about his injuries, and then you switch to liability, and assume it's a case where liability is close, he's going to be 2 hours away from the cautions that he had in mind. He's going to be 2 hours away from what his lawyer had to say to him about how best to deal with various questions, and perhaps you improve your chances of getting helpful testimony in that situation. No way to prove that, but it's the kind of thing that we all act on a basis of hunch, I would say. In terms of questioning techniques, I'll make one general observation, which I think is at the root of much that follows. And that is the observation that the order in which questions are asked and the way in which they are worded will affect the answer given, even by a truthful witness. So the order in which questions are asked and the way in which they are worded will affect the answers given, even by a truthful witness. And a very easy illustration of that is a friend calls you up and has 2 extra tickets to a play or a ball game or whatever it is. And you know 2 things instantly. You know you want to go, and you know that your spouse is not going to want to go. Not the kind of thing that he or she likes. Now, you tell your friend you'll call him back and let him know, and then you call home. A way to ask the question is to say, would you like to go to the play? Would you like to go to the ball game tonight? It's straightforward, it's easy, that's what you want to ask. Many of us will instinctively in that situation avoid asking that question because we know the answer. We know the answer is he or she does not want to go, so you have just increased the chances of a negative answer. Another way to do it is to start, first of all, by saying, do we have any plans for tonight? It may be wise to do that because if you don't do that, you're sometimes reminded of plans that you never knew existed and that you sometimes wonder where they came from. And then to ask a question, and there are countless ways to vary this, but to say something like, would you object to going to the ball game tonight, or to the play, or whatever it is? And you word it in a way, we all instinctively word it in a way to try to get the answer we want, to try to get a yes instead of a no. Now, the truth of the matter is that the facts have not changed. The basic fact is you want to go and your spouse does not. But you've tried to structure the questions, you've You've questions and worded your questions in a way to try to get the answer that you want. And as I say, I think that sense that matters is behind a lot of what follows here.
Dennis, is this what you refer to in your book as questioning to exhaust logical alternatives so that what the witness might have thought of as an alternative answer is eliminated before you get to the real question?
I think I should have said that, Dave.
Oh, okay. I think you did say it.
Okay.
I didn't make that up. It's in one of your books. It's in your book.
Let's try some different techniques. Just talk about them, and keep in mind, no one size fits all. No one size fits every witness. One approach is to coax the witness to give you the answer that you want. And very often the question will come in the form of something like, would it be fair to say that? So if you're preparing the witness, you may want to prepare him for questions coming that way. We all want to be fair, or it may come as, would you agree that? We all want to be agreeable. And what you want the witness to do is to discipline himself, herself, to filter out those adjectival descriptions and just deal with what follows. From the questioner's point of view, you may have the sense it will work with this witness. You will coax him or her to give the answer you want. In one case involving a serious injury as a result of a hazing incident at a certain university, the witness was asked the question, in light of all of this, the witness for the university, in light of all of this, did it come as a big surprise to you when you heard about this incident? And I should say this was the witness actually on behalf of the fraternity. And the answer was, of all of the chapters nationwide, I was least surprised to hear that something like that had happened at this campus. A very helpful answer for the plaintiff's lawyer, a very harmful answer from the defendant's point of view, and the question was, the key words were, did it come as a big surprise to you? But that may be the wrong approach to try to coax the witness. And again, I'm basically using examples that come from real cases. And in one case in which we were deposing the plaintiff in a predatory price-fixing case, or at least a predatory pricing case, one of the things we wanted to show was that even if the defendant's prices had been set 10% higher, and which we knew could not be shown to be predatory, even if the prices were 10% higher, the plaintiff would not have gotten any more business. So we had a kind of a contentious, argumentative witness, the last person in the world who was going to be coaxed, the last person in the world who wanted to be fair and agreeable. And so we put the question differently. We put the question to him, would you agree that if the defendant's prices had been 10% higher, you would have gotten a lot more business? And his sense being that we wanted a yes to that question, he answered no. And so effectively, he blew his own case out of the water in terms of proving causation and damages, because even if he got over the liability hurdle, and even if they proved our rates should have been higher, this witness effectively said he would get no more business as a result of that.
Dennis, let me give a little more explanation of that particular technique, because it's a good one. Most of our leading questions, our closed-end questions, lead to yes, which means that what we want the witness to do is agree with the proposition that we've made, and so we are suggesting within our question the proposition the witness will agree with the answer yes. Vast majority of our conclusion included leading questions lead to yes. However, when we have a disagreeable witness who isn't trying to be truthful, but is in fact trying to be argumentative and disagreeable with you, one of the reasons why it's sometimes important to wait a little bit before you get into these important questions is that you discover the witness, you learn the way the witness is reacting to your questions, and you figure out, as you obviously did in that setting, that this is not a witness who's going to give you a truthful answer. This is a witness who's going to give you a disagreeable answer. And so what you do is lead to no. In other words, you state the proposition within your question where, again, you know the witness is going to disagree with the proposition, but that's exactly what you want. In other words, you now have reformed your questions so that the desired answer is not a yes, but is now a no. And so it is a questioning technique that requires that you change from your normal questioning method of wanting the witness to give you a yes answer to now wanting the witness to give you a no answer, which you have done because you believe the witness is going to be a witness who is going to disagree with whatever proposition you put forward.
A very interesting way to put it all together. Let me talk about some other contrasting questioning techniques. Elsewhere in this program, we talk about the possibility of counsel for the plaintiff asking the defendant doctor, why did you decide to perform a cesarean section here right off the bat? Without any prelude, and talk about the pluses and minuses of doing that kind of thing. And it may be an effective approach in a given case. You get right to the key issue right off the bat and go from there. That could be not at all the right approach in a given case. And I'll mention a case, by contrast, I had some years ago, where the plaintiff alleged that he developed leukemia as a result of exposure to certain toxic chemicals in the workplace. And I represented one of the defendants, a chemical company, and one of the key defenses we had in the case was the statute of limitations, that the plaintiff should have known his basis for a basis for alleging that he developed leukemia as a result of such exposure more than 2 years before he started suit, which was the applicable statute of limitations. So we thought, well, one way to prove this, really the only way to prove that the plaintiff knew, because the plaintiff denied it, one way to prove it would be to take the deposition of the plaintiff's treating physician and ask him about what he told the plaintiff as to what was the cause of his developing leukemia. You could bring the doctor in, and we did, and you could say to him something like, did you ever tell the plaintiff that you suspected that his leukemia was due to the chemicals that he was working with in the workplace? And then question number 2, when did you first tell him that? Those are the questions we wanted answers to, and you could have asked and had the deposition over in less than 15 minutes if you just wanted to take those questions, those answers, and whatever follow-up there was. Our sense was that the doctor would not want to be in the position of giving testimony that would blow his patient's case out of the water, and would be inclined to say, human nature being what it is, that he did not remember, that he did not recall, etc. And so what we did was to get his medical records, and there were a number of references in the records at early enough dates so that the statute of limitations defense would be effective, a number of entries saying that the doctor noted that this fellow worked with, and chemicals might very well be the cause of the medical problem. And we went through them one by one and showed him that he had made those notations, And then we ask questions along the lines of, if you suspect the cause of a patient's illness, do you generally tell him? Is there any reason not to tell him? If you thought that it was due to somebody being exposed to chemicals in the workplace, would you tell the patient that so that he could avoid further exposure? Did your patient, in this case, ever accuse you of withholding information? Did your patient, in this case, ever threaten to bring a lawsuit against you? And only then, after all of that ground had been covered, did we put the question to him of when did he first tell the plaintiff that he thought there was a connection between the chemicals in the workplace and his medical condition. I would like to end the story by saying that he gave us the answer we wanted, and we prevailed on the statute of limitations. The truth is he did not. He did not give us the answer we wanted, but it was very obvious in giving us a different answer that he was squirming very uncomfortably, and we had at least the satisfaction afterwards of saying to ourselves, we did everything we could think of to maximize the chances of getting the answer we want. And I guess the only lesson of these last comments is, even if you do that, it may not work. But the part in your control is to do as much as possible to see that it does work.
So let me describe what I take from this particular example. First of all, I'm a big fan of moving quickly to important issues and asking the big questions when you believe there's a good chance you're going to get an honest and direct answer from the witness. So in this case, if the example you've just given, if I believed that the doctor was inclined to be truthful rather than evasive, or truthful rather than to pretend an absence of memory, I wouldn't have beat around the bush on the questioning. I would have started with the important question, or either put it first or near first in the order of business, and I would have asked the big question directly and immediately. This gives me the answer I want, and we can depart. However, in any case where there is a concern that the witness is not going to be honest or is going to pretend an absence of knowledge, then the early and direct question asked of the big and important issue is probably an ineffective technique. What you're going to do is force the wrong answer by asking it too early and too bluntly. So what Dennis has described is a course of questioning that is designed through the answers given by the witness to force the witness to intellectually come to the conclusion that a particular answer is required. Quoting from Dennis's book, ask questions designed to elicit answers, the intellectual force of which may cause the witness to discard his or her original inclination to claim no knowledge. This is in the section of Dennis's book on dealing with the witness who you know is going to pretend to not remember, which is the toughest of all witnesses we deal with. And in the case that Dennis is describing, the witness, the doctor who could have case-ending testimony for the patient, you would naturally believe was going to be supportive of the patient and would pretend an absence of knowledge. So what Dennis did is ask a series of questions that were designed to be answered by the witness in a way that would force the witness through his own answers to come to the conclusion that he really should know the answer and that the answer will be favorable. Now, as what happened in Dennis's example, it doesn't always work. In fact, probably even the majority of times, it won't work. You won't force a witness who's inclined to be unhelpful to become helpful through this questioning technique. But you stand a much better chance of getting a better answer by using the technique that Dennis has just described than simply bluntly, quickly asking the question that you know you're going to get the wrong answer to.
That's what we're struggling with. Another questioning technique that I like to use, and I think can be very effective, is establishing the obvious. And there's a tendency, I think, for us to focus on what is it that we want to learn, or to seek some soundbite admission that is going to win the case. But something else that is a good place to focus are some obvious facts that are helpful to you, and to ask the witness on the other side to confirm that, yes, those are the facts. And in one case, for example, which involved it was a product liability case, a fellow of the college, Jerry McHugh, was on the other side representing the plaintiff, and it was a case where a boiler worker was badly injured when the seam on a cylindrical bin split and hot ash came out of the bin at 600 degrees Fahrenheit and sprayed him. Needless to say, he was very badly injured. And in deposing the principal employee of the defendant, the designer engineer, Jerry asked these questions. This bin holds 95,000 pounds of ash, right? And it is heated to 450 to 600 degrees Fahrenheit. And at that temperature, the ash flows like a liquid. In fact, your operator's manual warns that at this temperature, the ash will flow like hot water if it should become loose. And at another point, the manual describes the ash as like molten lava, correct? None of these things was in dispute in the case. All of them were, in that sense, were obvious. Jury would have no difficulty in establishing these points at trial. But by asking about them at the deposition and getting a statement, the bin holds 95,000 pounds of ash, right? Answer yes. And it's heated too. Answer yes. You have a section of the deposition that can be used either when you cross-examine at the time of the trial. The witness is going to know you have that script right in front of you, or you can stand up and read it, and again, a very compact statement.
And again, let me emphasize that we're not only doing discovery in the course of a deposition in the sense of trying to learn information we don't already know, but we're also trying to use the deposition to establish or prove a point that we know we don't need to learn, but we want the record to have it confirmed. So in the example that Dennis has just given, a summary judgment motion, it might be a rather extensive process to try to establish for the basis of a summary judgment motion those same points that could be much more readily established by having asked those questions in deposition. So not only sound bites for trial, but also as support for summary judgment or other motions, it's helpful to ask these kinds of obvious questions. And as we showed in the earlier example, sometimes we ask the obvious in order to establish for the witness that the witness's own answers compel the answer to the question that the witness would have otherwise potentially disputed.
Another technique is stating the other side's position starkly. And the idea is to take what the other side alleges. It would typically be the plaintiff, but it could be the other way. And saying to the plaintiff, do you really allege that? For example, very often in a case involving breach of contract, there will also be a fraud count. Not only did the defendant breach, but the defendant defrauded me, etc. And an approach that works in a surprising percentage of cases is to say to the plaintiff, do you contend that Mr. So-and-so, the key person involved in the transaction for defendant, do you contend that he lied to you when he said whatever it is that's at issue? There's a natural inclination or disinclination to say that someone has lied. You may say, it's much easier to say they breached the contract, something was misrepresented, etc. But if you personalize it and you say, are you saying this person lied to you? Very often the response would be, I'm not saying that. I am saying that he breached the contract, or I don't know whether he lied or he didn't, which again is very helpful, obviously, from your point of view. Another example I'll use is a case where the parties entered into a letter of intent with respect to the sale of a business, and then it never went forward. And I represented the plaintiff in that case, and we were contending that the letter of intent itself created a legal obligation, and the defendant was contending that no, the letter of intent did not create any binding obligations. It was just a general statement of intent that we would agree to agree. Typically, both sides negotiate that kind of a document with the idea that they want the other side bound, but they don't want to be bound themselves, and so they sometimes end up being very ambivalent types of documents. In that case, early on in the deposition of the key guy on the other side, I asked him this question. Is it your view that the letter of April 18, whatever year it was, which has been marked Exhibit 2, created no obligations upon your company? Okay? Is it your position that the letter created no obligations upon your company? That was exactly his company's position. And his answer was no. And this was a bright, well-educated, experienced guy, but he said no. And I think it was because it was put to him so starkly that it just sounded wrong to say we have no obligations. And instead of saying, yes, that's my position, after saying no, he said, no, it isn't. I believe we had obligations to proceed in good faith. That was our position. So where did the answer come from? I think this was one of those times when you decide I'm going to use this technique and it works, because it just sounds wrong to say, yes, that's my position because it's stated so harshly.
This is one of those low-risk, high-reward questioning techniques that a lot of lawyers use. Not only defense lawyers use it on plaintiffs, but as Dennis just demonstrated, plaintiffs' lawyers can use it on defense representatives. I call, rather than, as you say this, stating the other side's position starkly, my description of the technique is to, through your questioning, push the witness's testimony to its illogical extremes and state the testimony as extreme as it would be illogical that would be taken. If what they've said is true, then necessarily the next extension becomes true. Now, the reason we do this is that in many cases, the witness will refuse to have their position stated in its illogical extreme or stated so starkly, and will rebuff it, will refuse to agree with it. And that's exactly the example that Dennis just described, where the witness, when having heard it stated so starkly, rejects it. Now, I might have even stated it more extreme and said, Is it in fact your position in this litigation that that letter created absolutely no legal obligation whatsoever? As extreme as I can say the same concept, which is that there was no binding effect of the agreement. And having heard it stated so starkly and in such an extreme position, many witnesses say, no, that's not really my position. They will not tolerate their position having been stated so starkly and therefore reject it. On the other side, the reason why this is so frequently used against personal injury plaintiffs is that some witnesses will never reject the extremities to which their testimony will be placed. They will continue to allow their description to be moved past any description of logic into something which becomes so obviously extreme that any juror listening to the testimony would know that it's being exaggerated by the witness. You don't let the witness create the exaggeration, you create the exaggeration, and the witness then agrees to it, and it winds up showing that the witness isn't credible.
Yet another technique, and that is to look for an opportunity to use the either-or question. And it will often be asked in terms of, did it occur to you at that point? And it can be used in both personal injury and commercial litigation, and I think of it as the either-or question because you don't care whether the witness answers this way or that way. There is something to be made out of either answer. So, for example, in a personal injury case, you may say to the other driver something like, when you saw the other vehicle approximately 20 feet away from the edge of the intersection, did it occur to you at that point that an accident was about to happen? Witness says yes, or the witness says no. If the witness says yes, then all of his subsequent actions are judged in terms of it has occurred to him that an accident might be about to happen. So, did he apply his brakes? Did he swerve, etc.? If he says no, then you're in a position to say, so that up to that point there was nothing unusual about the movement of my driver's car that caused you to think you were about to have a collision. You can make something out of that. In commercial litigation, if you're going through, let's say you have a complicated fraud case, and you're going through step by step by step, the individual actions that were taken that ended up with the plaintiff losing a lot of money, as you go through each step, you can say to the plaintiff, did it occur to you at that point that the defendant might be perpetrating a fraud upon you? If the answer is yes, then again, everything that he did after that will be judged in terms of, it has occurred to him that this fellow might be trying to defraud me. And so it's then a question of, is he then reasonably relying, for example, on subsequent statements by the defendant? If the answer is no, that it did not occur to me, then you're in a position to make the argument that, well, nothing up to step 6 struck you as something that was outside the bounds of normal business conduct. Nothing up to that point caused you to think that you were about to be defrauded. So either answer, you may prefer one to the other in a given situation, but whichever way the witness answers, there is grist for the mill from your point of view.
All of these questions are examination of the subjective thought processes of the witness. And one of the distinguishing features between attorneys who really don't do an effective job in taking a deposition and those who do is that really good lawyers understand that they're not just questioning about what could have been observed, objective events. What did you do? when did you do it, who was there, what was said, but also examine the thoughts of the witness and what conclusions the witness had drawn at certain points along the timeline. And that's exactly what Dennis has pointed out here, is that there is a lot more value that can be obtained through the questioning because the questions have been asked about what the conclusions had been and the thoughts had been of the witness at various times. Did it occur to you that an accident was about to happen, or did it occur to you that you were potentially being the victim of a fraud, or the kinds of evaluative thought processes that a lot of lawyers forget to ask about but can be very effective when you do ask about them.
And one final technique that I'll mention is stepping into the deponent's shoes and trying to figure out what actions would he or she have taken if the facts were as they now say, and more important, if you're talking about an adversary, what actions might they have taken that would be inconsistent with their current position. In one landlord-tenant dispute involving a commercial property where it involved fairly hefty rent, the tenant and the landlord had been not only dealing with each other in this business transaction, but were very good friends, etc., beyond that. And they met at some point in connection with renegotiating the lease, and it became apparent that the landlord wanted more rent than the tenant was willing to pay. And so the tenant said at this last meeting, well, when I get back to the office, I'll send you a certified letter telling you that we're not going to renew the lease, which is what was required under the lease. And according to the tenant, the landlord said, oh, don't bother to do that. You and I we've been like brothers for many years. And brothers don't send certified mail to each other. And I won't have any difficulty finding a new tenant. The tenant said later that he thinks that was really how the landlord felt at that time. He later had difficulty finding a new tenant, and so because the tenant had not sent him this letter, he claimed that the lease had renewed and that he was entitled to have rent from this tenant for another 5 years. And he denied ever saying there was no need to send the letter, etc. So you step back and you say to yourself, well, now, let's suppose that things happened the way my client, the tenant, says. And let's suppose that the landlord thought there won't be any problem and only later reversed field. What would the landlord have done after that meeting? And there are things like he would have prepared advertisements for the space. He would have contacted a broker and attempted to retain a broker to find a new tenant, etc. And if you ask about those actions, and you find out that, yes, he did walk out of that meeting and have prepared an advertisement for the space, he did walk out of that meeting and start making calls to potential brokers, then that's very consistent with the tenant's account of what happened and inconsistent with the landlord's later version that there never was any understanding that the lease had been terminated.
The short way that I think of this is my description for what Dennis has just described is ask questions designed to determine if the witness took acts which were either consistent or inconsistent with the position that is now being asserted. Again, ask questions that are designed to find out if the witness engaged in actions that were either consistent with or inconsistent with the position that is now being asserted. So, for example, as Dennis gave, that if the witness had believed that the lease was about to terminate, he probably would have began looking for a new tenant. And there would have been certain actions that would have been inconsistent with the current position, but consistent with the possibility that he recognized that a new tenant was going to have to be found. So whenever you're challenging the testimony that you're hearing, listen to the witness and think that. If the witness's testimony were true, what would the witness have done that would have been consistent or inconsistent with that position now being asserted, and ask questions to see if either of those took place.